Robot arms loading and unloading sheets of float glass from a rolling conveyor belt. Figure 1-1, credit, modification of work, float glass unloading by ICA plant/Wikimedia. Org, CC by 3. 0. Chapter outline. 1-1, the foundations of patent protection. 1-2, the weakness of early patent systems. 1-3, America's uniquely democratic patent system. 1-4, the role of the U.S. legal system. 1-5, what the U.S. patent system wrought. 1-6, patent-eligible inventions. 1-7, criteria for patenting. 1-8, other types of patents. 1-9, the patenting process. An image of the first U.S. patent. In barely legible writing, the patent number X000001 is seen with the date July 30, 1790. The United States seal is visible. Figure 1. 2. The first U.S. patent credit. U.S. Patent Office via Wikimedia Commons/public domain. Learning objectives. After completing this section, you will be able to describe the philosophical logic behind granting patents. Describe the role of patents in fostering invention. Do patents really promote innovation? Before reading this section, please watch the overview video below covering the usefulness of patents. How ironic that a system for granting exclusive rights to inventors is the greatest vehicle for knowledge sharing and technology transfer ever devised by human beings. What is a patent? A patent is an intellectual property right granted by the government of a nation to an inventor that gives them the exclusive right to the invention for up to 20 years, in exchange for disclosing the details of the new technology to society for its ultimate benefit. In the United States, a patent is a legal instrument in the form of a document issued by the United States Patent and Trademark Office, USPTO. It gives the inventor of any new, useful, and non-obvious machine, process, manufacture, or composition of matter the right to exclude others from making, using, offering for sale, or selling the invention throughout the United States or importing the invention into the United States for a limited time in exchange for public disclosure of the invention. A U.S. patent is only recognized domestically and cannot be enforced in another country. History of patents in the United States. The legal foundation for U.S. intellectual property rights was laid by the founders in 1787. In the very first article of the U.S. Constitution, which outlined the precepts of our democratic society. In Article 1, Section 8, Clause 8 of the Constitution, Congress was given the authority to promote the progress of science and useful arts by securing for limited times to authors and inventors the exclusive right to their respective writings and discoveries. Roman 2. America was the first country in the world to enshrine intellectual property rights in its national constitution, and the founders did this quite deliberately, says B. Zorina Khan, an economic historian at Bowdoin College, whose book, The Democratization of Invention, Patents and Copyrights in American Economic Development, was awarded the Alice Hanson Jones Prize for an outstanding work in economic history. Roman 3, to the men who gathered in Philadelphia to promote the general welfare, Khan wrote, it was self-evident that ideas, industrial and cultural inventions, and democratic values were integrally related. American democratic institutions would ensure that rewards accrued to the deserving based on merit, rather than on the arbitrary basis of class, patronage, or privilege. Indeed, the founders viewed intellectual property rights as vital to the new nation's economic survival. As George Washington himself stated in his first annual address to Congress in 1790, the advancement of agriculture, commerce, and manufactures by all proper means will not, I trust, need recommendation. But I cannot forbear intimating to you the expediency of giving effectual encouragement to the introduction of new and useful inventions. The question is, with all the challenges they faced, why did the founders think it so crucial to create a strong intellectual property system? Their reasons were both universal, i.e., applying to all societies, and also very particular to America's revolutionary experience. Bargain theory versus natural rights theory. Every society that affirms intellectual property rights offers two justifications for doing so: the bargain or contract theory and the natural rights theory. Bargain theory. The bargain theory starts with the common sense premise that people will be encouraged to invent new products and services that benefit society, if they are likely to profit by doing so. The U.S. Constitution thus offers inventors a bargain. If you invent something useful, e.g., a cotton gin in 1794 that boosted agricultural production 100-fold, or a semiconductor 163 years later that sparked the creation of a trillion-dollar new industry and millions of jobs. Then the Constitution and statutes say that, as a quid pro quo, you can have the exclusive right to that invention for a limited time, after which it goes into the public domain and belongs to society. An hand-drawn schematic of a semiconductor. It is labeled October 28, 1969, and has the names George MacIver and James Bowie. The image shows what appears to be a flat plate with various components labeled. Figure 1.3 patent for an electrode lead for semiconductor devices. Credit: U.S. Patent Office via Wikimedia Commons/public domain. There is something so simple, yet economically potent about this concept. As Abraham Lincoln, America's only presidential patentee, number 6469, for a device to lift boats over shoals, noted, the beauty of the patent system is that it added the fuel of interest to the fire of genius. Natural rights theory. The natural rights theory, meanwhile, invokes another common-sense premise that most of us instinctively hold to be true: that the product of mental labor is by all rights the property of its creator, no less than the product of physical labor is the property of its creator, or of the person who purchases it from that creator. This is what Daniel Webster was referring to when he said, "The American Constitution does not attempt to give an inventor a right to their invention, or an author a right to his composition. It recognizes an original, pre-existing, inherent right of property in such invention or composition. This right is not absolute, of course, and inventors' inherent rights may at times be circumscribed by national security or other concerns. But in exchange for disclosing to the public the nature and details of the invention, the Constitution authorizes the government to enforce the inventor's exclusive property right to that invention for a limited time." A photograph of Daniel Webster. Figure 1. For Daniel Webster, an American lawyer and statesman. Credit: Wikipedia/public domain. Two important public policy goals are thus served. The inherent property rights of inventors and authors to their creations are protected, thereby helping to ensure that the wellsprings of creation and productivity do not dry up for lack of incentive. And yet the benefits derived from these inventions and creations are ultimately harnessed to the public good through disclosure, thus promoting the progress of the nation and the general welfare of its citizens. How patents foster innovation. To help understand why patent rights not only encourage inventors, but also promote the wider diffusion of new technology for the benefit of society. Economic historians Naomi Lamoureux and the late Kenneth Sokoloff suggested the following thought experiment. Imagine a world in which there was no patent system to guarantee inventors property rights to their discoveries. In such a world, inventors would have every incentive to be secretive and to guard jealously their discoveries from competitors because those discoveries could, of course, be copied with impunity. By contrast, in a world where property rights in invention were protected, the situation would be very different. Inventors would now feel free to promote their discoveries as widely as possible so as to maximize returns either from commercializing their ideas themselves or from licensing rights to the idea to others. The protections offered by the patent system would thus be an important stimulus to the exchange of technological information in and of themselves. Moreover, it is likely that the cross-fertilization that resulted from these information flows would be a potent stimulus to technological change. Roman 4. It's more than just likely. Extensive research in the United States and other nations shows that patents have served as a powerful stimulant to technological knowledge sharing. A 2006 survey published by the French economists François Lévesque and Yann Meniere, for example, found that 88% of U.S., European, and Japanese businesses rely upon the information disclosed in patents to keep up with technology advances and direct their own R&D efforts. Patents don't block innovation, they promote it. From the earliest days of the United States, patent and legal records show how inventors, including Thomas Edison, regularly kept abreast of developments in their fields. They did this by studying patent descriptions published by both the USPTO as well as by industry publications such as Scientific American, which was founded in 1845 by Munn and Company, the leading patent agency of the 19th century, expressly to spread new technological knowledge and facilitate the buying and selling of patents. For example, Elias E. Ries, inventor of a number of devices to exploit the heat generated by electrical currents, reported that when he read in the Official Gazette in 1886 about a patent issued to Elihu Thomson for a new method of electric welding, there immediately opened up to my mind a field of new applications to which I saw I could apply my system of producing heat in large quantities. Roman 6 in many industries, specialized journals kept readers informed about new patents of interest. In fact, new research in 2012 discovered that rather than blocking development, Thomas Edison's seminal 1880 incandescent lamp patent, No. 223,898, actually stimulated downstream development work that resulted in new technologies of commercial significance, including the Tesla coil, hermetically sealed connectors, chemical vapor deposition process, tungsten lamp filaments, and phosphorescent lighting that led to today's fluorescent lamps. Roman 7. Even the word patent signifies its social purpose of disclosure. It is derived from the Latin patent meaning open, and is the present participle of patere, meaning to stand wide open. This explains the origin of the term letters patent, letters that lie open, which refer to the patent documents issued by the English Crown. These were not closed with a seal, but were instead kept open, with the seal hanging at the bottom, notifying all not to infringe upon the patent. An image of a front page of Scientific American from 1845. The featured article is of an improved rail car. Figure 1.5 front page of the first Scientific American issue, August 8, 1845. Credit, modification of work by Scientific American via Wikimedia Commons/public domain. As with any economic and legal instrument, patents have the potential to slow innovation if their grant of exclusive rights is too broad. But the overwhelming preponderance of economic research and real-world experience demonstrate that, on balance, intellectual property rights tend to stimulate invention, economic growth, and the diffusion of new technological knowledge in every country where they exist. This fact by itself, however, does not explain why the U.S. patent system became a model for much of the world. To understand why it did, and how it helped build the most successful economy in the history of the world, we must examine the revolutionary design of the U.S. patent system itself and the ways in which it overcame the weaknesses of earlier patent systems. A picture of a few feather quills with an ink jar. Figure 1.6, credit, modification of work, ink jar and quills, by student of rhythm via Flickr/CC by 20. Learning objectives. After completing this section, you will be able to outline the history of patents from antiquity through the 1700s, identify flaws in early European patent systems, history of patents, 500 BC to the 1700s, given the common-sense logic of granting patents to stimulate invention. It comes as no surprise that patent-like incentives date all the way back to antiquity. In the ancient Greek city of Sybaris, located in what is now southern Italy, in 500 BC, encouragement was held out to all who should discover any new refinement in luxury, the profits arising from which were secured to the inventor by patent for the space of a year. Roman 8, the first formal patent legal institutions, were developed in the Republic of Venice in the mid-1400s. The Venetian Statute of 1474 decreed that the inventors of new and useful devices would be protected from infringers and copiers for 10 years so long as they disclosed the details of their inventions. Most Venetian patents were granted in the field of glassmaking, and when a large number of these glassmakers emigrated to other countries in Europe, they sought similar protections from the local authorities. This is how the notion of patent rights and their expression in patent legal systems began to spread and gain acceptance throughout Europe. Initially, however, English and French monarchs used patents not simply to stimulate invention, but also to grant exclusive trade monopolies to those favored by the court. In the reign of Elizabeth I in the latter 1500s, some 50 patent monopolies were granted over the trade in such staples as salt, soap, starch, iron, and paper. Critics said these enriched the monopolist and robbed the community, while doing absolutely nothing to stimulate new technology or industry. A growing public outcry ultimately forced Elizabeth's successor James I to revoke these grants of trade monopolies in 1610. In 1624, the Statute of Monopolies formally repealed the practice and henceforth restricted patent rights solely to new inventions. A painting of Queen Anne, Figure 1. 7 portrait depicting Queen Anne of Great Britain by John Closterman, circa 1702. Credit: Workshop of John Closterman via Wikimedia Commons/public domain. European countries made several other important innovations in their early patent systems. In the mid-1500s, France became the first to publish patent descriptions from inventors who chose to submit them. England, under the reign of Queen Anne, 1700 to 1714, was the first to require inventors to submit a written description of their patent to describe and ascertain the nature of the invention and the manner in which it is to be performed. And in 1729, France began to publish abbreviated digests of patent descriptions, but these were intermittent and subject to delays of up to 60 years after the patents were originally granted. As might be expected, this lack of regularity limited the technological knowledge sharing that is one of the great benefits of a patent system. Flaws of early patent systems. Old World patent systems suffered from other major weaknesses as well. Patents for inventions imported from other countries were regularly granted, increasing the incentive for would-be patentees to copy the creative work of others rather than invent for themselves. And there was generally no systematic examination of patents by technical experts, in part because this was viewed as an intrusion upon the prerogatives of the Crown. But the biggest problem with early patent systems was that they all shared a tendency to reinforce the wealth and prerogatives of elites, not the welfare and productive capacity of the whole of society. In Britain, patents were favors granted by grace of the Crown and were often only secured through court connections. They were also subject to any restrictions the government cared to impose, including the expropriation of the patent without compensation. Roman 9. What's more, patent application fees were prohibitively high, more than 11 times the per capita annual income of the average British citizen, which put the system out of reach of all but the wealthy. Yet ironically, in the parliamentary debates over the patent system, the exclusion of the working classes was regarded as one of the chief virtues of the British patent system. British patent law also severely limited the ability of inventors to sell or license the rights to their discoveries. As noted in a contemporary 1832 book entitled A Practical Treatise on the Law of Patents for Inventions. This restriction, along with working requirements. These were regulations that forced patentees to manufacture products based on their patents within 2 or 3 years of issuance or lose their patent rights, limited innovation activity mainly to those who had the factories or the ready capital to build them, needed to produce such products. These rules had 2 significant effects upon the British economy. They restricted innovation to only a small sector of the population, rather than unleashing the creativity and productivity of the whole people. And they created a bias toward inventions that enhanced the market dominance of incumbent, capital-intensive industries, rather than opening up new markets for the sorts of disruptive new industries that usually drive economic progress. European societies were organized in ways that concentrated power in the hands of elites and facilitated parasitic, rent-seeking by favored producers. Notes historian B. Zorina Khan. The organization of invention was no exception. A society that restricts invention to elites can generate exceptional gains early on, but the initial spurt is unlikely to be maintained. Indeed, the result in Britain was unbalanced and narrowly focused economic growth. Inventors faced high transaction and monetary costs, a limited market for their inventions, and a great deal of uncertainty. Diffusion of new technological knowledge was severely inhibited, and the rate of technological change was adversely affected as a result. Eventually, Britain's initial leadership of the Industrial Revolution had more to do with its large existing commercial holdings and manufacturing base, and its vast stores of amassed capital, than with systemic or broad-based encouragement of innovation within British society. The changing tide, the elitist nature of early patent systems, reflected the feudal economic relations that dominated that era. But by the late 18th century, capitalist economies were beginning to emerge across Europe, and in Britain, nationwide lobbies of manufacturers and patentees called for an overhaul of the patent system to bring it in line with this new economy. The needed reinvention would come not from Britain, however, nor even from France, which had its own democratic revolution soon after America's. Instead, it took place in the newly liberated United States, where a vibrant capitalism unburdened by centuries of entrenched feudalism was developing. This, then, is the story of one of the most admired of all American inventions, the modern democratized patent system, now used widely throughout the world. Learning objectives. After completing this section, you will be able to explain the role of the Founding Fathers in developing the U.S. patent system. Explain the 6 unique features of the U.S. patent system. Never mind that intellectual capital accounts. A patent system for everyone. Before reading this section, please watch the overview video below covering why America developed the world's first patent system for the common man, and what we got out of it as a result. Hint: the strongest economy on the face of the earth. Never mind that intellectual capital accounts for 55% of total U.S. GDP today. Or that it represents up to 80% of the market value of all public companies in the U.S. Roman 12 to most citizens today, patents and other intellectual property are inscrutable mysteries. But to America's founding fathers, they were matters of the highest national importance. The challenge facing the founders, the people who led the revolution and were later tasked with writing a constitution, were not concerned simply with creating lasting political structures that could defend the hard-won freedom and sovereignty of the newly liberated colonies. They also struggled to stimulate the rapid growth of industry to ensure the new nation's economic survival. The survival of the United States of America was far from certain in those days. It was a backward agrarian economy, dependent on imports and lacking major domestic industry, with a population of barely 3 million inhabitants. Britain, meanwhile, with whom the United States had just fought a war and would soon fight another, had 3 times the U.S. population, boasted the most powerful economy on Earth, and was the unrivaled leader of the emerging Industrial Revolution. Similar to 1756 cartoon on Minorca, Lord North carries a large sack entitled Budget as he drags the British lion on a chain behind him. The lion has lost one of its paws, labeled America, to an American Indian's tomahawk. The Indian says, "This limb belongs to me in spite of fate." To the rear, Burke and other members of the associations prepare to intervene. Figure 1-8 political cartoon circa 1780 titled The English Lion Dismembered or the Voice of the Public for an Inquiry into the Public Expenditure. Credit. Modification of work by BPL via Wikimedia Commons/CC by 20. It was, therefore, a critical task of the leaders of the new American nation to design institutions, including a patent system, that would encourage economic activity and investments to spur the growth of America's primitive economy. It's important to note that although the founders deeply believed in democratic ideals of government, they were not wild-eyed idealists. They were very practical people who faced an overwhelming challenge. How do you build a national economy from scratch, one that can prosper without British imports? To do that, they needed to mobilize every asset they had. Unlike Britain, however, America had no significant capital or commercial assets. In fact, the American standard of living at that time was actually lower than in many of their South American neighbors. Roman 13, all America had was abundant, but still untapped, natural resources, and a population widely regarded in the world as uniquely enterprising and independent-minded. Ours was the world's fastest-growing population, doubling in size every 20 years. Americans were also widely literate, albeit mostly lacking in higher education, and informed by what Washington Irving called the general diffusion of knowledge. Most important, unlike the tenant farmers and laborers who made up the bulk of England's rigid class society, the vast majority of Americans were freeholding small farmers, merchants, shopkeepers, artisans, and mechanics, the forerunners of what we today call the middle class, who were possessed with what publisher Hezekiah Niles called a universal ambition to go forward. This was America's principal asset, their ace in the hole. And men such as George Washington, Thomas Jefferson, and James Madison knew they had to find a way to unleash the creative and productive potential of these independent citizens if the country was to industrialize and survive. Incentives needed to spur economic growth. As Jefferson wrote to his daughter Martha in 1787, it was precisely because America was bereft of Europe's vast resources and left to its own devices that we are obliged to invent and execute. To find means within ourselves and not to lean on others. But how to do that? From the historical record, it appears that the founders quite consciously sought to construct a patent system that would do what no other patent system in the world had ever done before, namely, stimulate the inventive genius and entrepreneurial energy of the common man. As noted earlier, the first thing they did was to affirm inventors' and authors' rights in the U.S. Constitution itself. Although the intellectual property clause was ultimately adopted by unanimous consent of the delegates on September 5, 1787, there had been some debate about the issue. Thomas Jefferson, in particular, had expressed reservations about the wisdom of granting temporary monopolies, i.e., patent rights, given that Americans had just waged a bloody war of independence to overthrow the British monopoly of trade and political power. But as other delegates noted, and Jefferson eventually came to realize, a monopoly of trade is a far cry from the temporary incentives granted to inventors in return for the benefits they provide society. How can the exclusive right of an invention be compared with a monopoly in trade? D.P. Holloway, a commissioner of patents, would later argue in his 1863 annual report to Congress. How can the exclusive privilege to sell salt in Elizabeth's time, which added not 1 bushel to the production, but which enriched the monopolist and robbed the community, and the exclusive right of Whitney to his cotton gin, which has added hundreds of millions of dollars to the products and exports of the country, be both branded with equal justice with the odious name of monopoly? Roman 14. A portrait of Thomas Jefferson. Figure 1. 9 Portrait of Thomas Jefferson by Rembrandt Peale, circa 1805. Credit: Rembrandt Peale via Wikimedia Commons/public domain. In the words of Louis Wolowski, Chair of Industrial Economics at the Conservatoire des Arts et Métiers, inventors, rights under patents, are called monopolies only from the poverty of language, which has failed to express in words a distinction which no less clearly exists. The founders understood this distinction clearly. Rather than monopolists, says historian Kahn, patentees were viewed as beneficent contributors to progress, and the consistent goal of those who shaped the system was to encourage domestic ingenuity, whatever the social class of the inventor. Roman 15. Or as James Madison put it in Federalist Paper 43, the public good fully coincides with the patent rights of individuals, creating a new type of patent system. The real genius of the founders, however, lay in the way they consciously integrated democratic principles into the design of the world's first modern patent system, principles that had a profound impact on the pace and direction of U.S. economic growth. These were reflected in 6 fundamental innovations in our patent system that departed from European practice. Low fees, making patents affordable. The original patent law passed by Congress on April 10, 1790, deliberately set patent fees to a level any ordinary citizen could afford, initially $3.70, but 3 years later raised to $30. This was still less than 5% of the rate in Britain. Patent fees remained $30 for the next 70 years, ensuring that virtually any citizen could participate in the Industrial Revolution. The results were dramatic. Whereas most of Britain's handful of inventors came from privilege, the vast majority of America's thousands of inventors came from humble beginnings. They included farmers, factory workers, merchants, mechanics, and other artisans. Of the 160 so-called great inventors of 19th century America, over 70% had only a primary or secondary school education. Many had no formal schooling at all. And some of the most famous names in American invention, Matthias Baldwin, locomotive, George Eastman, roll film, Elias Howe sewing machine, and Thomas Edison electric light and phonograph, had to leave school early to support their families. A photograph of a steam locomotive in a museum. The locomotive body is a large cylinder, and it has a tall chimney stack emerging from the front of the body. Figure 1:10, one of Matthias Baldwin's early locomotives, the Memnon. Credit, Internet Archive book images via Wikimedia Commons/no restrictions. What's more, in another sign of economic democratization, most U.S. inventors had no formal scientific or technical training. They had only the general knowledge common to citizens of the day, plus whatever they taught themselves. What distinguished them was their ingenuity in applying that general knowledge to the practical problems of daily existence, and then exploiting the commercial opportunities that arose as a result. In short, they were entrepreneurial. The rapid growth of inventive activity during early American industrialization was characterized by a disproportionate increase in the involvement of segments of the population with relatively common sets of skills and knowledge, note Sokoloff and Kahn, rather than being accounted for by an elite who possessed rare technical knowledge or commanded large amounts of financial resources. The rise in patenting coincided with a broadening of the ranks of patentees to encompass many individuals, occupations, and geographic districts. Roman 16, making the patent system inexpensive, invited everyone's participation. In the words of Englishman John Stanfield, quoted in an 1880 issue of Scientific American, "The cheap patent law of the United States has been, and still, is the secret of the great success of that country." Simplifying application procedures. The founders greatly simplified administrative procedures in applying for a patent. This was no small thing when you consider that British applicants were forced to seek approval from 7 different offices, and then twice, obtain the signature of the king. If they wanted a patent that covered Scotland and Ireland as well, they needed approval from 10 more offices. British patent procedures were so Byzantine, in fact, that author Charles Dickens wrote a spoof of them entitled A Poor Man's Tale of a Patent, in which his main character, an inventor, is forced to seek approvals from 34 offices, some of which had been abolished years before and no longer existed. Obviously, few inventors could hope to run this gauntlet successfully, unless they had the wherewithal to hire very expensive patent agents to assist them. In the United States, on the other hand, applications only needed the approval of a single patent office, which created repositories throughout the country where inventors could drop off their applications and models and have them forwarded to the patent office at government expense. Rural inventors could even apply for a patent through the mail, postage-free. This last perk for rural inventors turned out to have a big impact on the course of U.S. economic development. While most British industrial breakthroughs were confined to London or other big cities, U.S. inventions were widely distributed across the country, in urban and rural areas both. The result was broader-based economic growth and less income inequality in the United States. Spreading new technological knowledge. Another unique feature of the U.S. patent system was its systematic effort to spread new technological knowledge throughout society, thereby creating a virtuous circle of innovation, begetting more innovation. In Britain, patents were only open to public inspection after paying a fee, and until 1852 were not even officially printed, published, or indexed. In France, printed information about patents was limited to brief titles in patent indexes, intermittently published and only available in the office in which these had been originally filed. By contrast, the first U.S. patent law explicitly stated that copies of patent specification together with similar models are to be made at the public expense and lodged in each state. Roman 17, in addition, as noted in the previous section, a plethora of publications by government and industry enabled any citizen with an interest to keep abreast of the latest patented technologies, examining patents for validity. In a very crucial departure from old world practice, the founders created the world's first examination system for patents to ensure their novelty, non-obviousness, and utility. The examinations were initially conducted by a committee composed of the Secretary of State, Thomas Jefferson, Secretary of War, Henry Knox, and Attorney General Edmund Randolph. But this was found to be cumbersome, so in 1793, a simple registration system was established. It turned out, however, that without the examination of applications for novelty, non-obviousness, and utility, the validity of issued patents began to be questioned. So the reforms of the 1836 Patent Act specified that henceforth applications would be scrutinized by technically trained examiners to ensure that the invention represented a genuine advance in the state of the art. For the first time anywhere in the world, the criteria for granting a patent depended solely upon the merits of the application rather than the identity or the mere say-so of the inventor. The situation was very different in Europe. In France, the following caveat was printed on each patent. The government, in granting a patent without prior examination, does not in any manner guarantee either the priority, merit, or success of an invention. Imagine trying to interest a group of investors in your new invention with that kind of warning label attached to it. In Britain, meanwhile, the lack of any examination of patent validity made the purchase of a patent right highly speculative and costly, thereby limiting investment in new technology. By contrast, says Kahn, the U.S. examination system reduced uncertainty about the validity of patents and provided interested parties with a signal of their potential value. This proved to be crucial in facilitating the growth of an extensive market in the sale and licensing of valuable patent rights, the first large-scale market of this type in the world. No working requirements, reduced monopoly control. The fifth distinguishing feature of the U.S. patent system was the lack of any sort of working requirements. In the debate over H.R. 41, the bill that became the first U.S. patent law in 1790, the Senate suggested requiring patentees to make products based on the patent or license others to do so. But the House rejected this as an infringement of patentees' rights. Roman 18. Indeed, the founders believed working requirements would only strengthen monopoly power and skew invention toward incumbent industry by limiting patents to those with the factories, or the capital to build them, needed to manufacture products from their inventions. Roman 19. In short, the founding fathers of this nation deliberately and quite consciously created what we now call non-practicing entities, NPEs, in order to expand the pool of inventors in their then backward economy to include ordinary citizens without the wealth or resources to commercialize their own inventions. And it worked, leading to a dramatic surge in innovation in 19th century America as large numbers of ordinary citizens started inventing and then licensing their discoveries to enterprises for commercialization. By 1865, the U.S. per capita patenting rate was more than triple that of Britain's, according to the annual reports from the commissioners of patents in both countries, and by 1885, it was more than quadruple that of Britain. Each U.S. patentee was also far more prolific than their British counterpart, so by mid-century, the United States was patenting 5 times the number of inventions as Britain each year, even though the populations were then equal in size, creating a market for new technology. The sixth unique feature of the U.S. patent system, and along with the refusal to impose working requirements, the one that had the greatest impact on future U.S. economic growth was an explicit provision for the sale of patent rights that both the courts and the U.S. Patent Office acted to facilitate. Roman 20. Why facilitate the buying and selling of patents? Because doing so enabled ordinary worker or farmer inventors without the capital to commercialize their own discoveries to still participate in inventive activity and earn income by licensing or selling their patents to enterprises that could. This ability to license patent rights, along with the low application fees, turned inventing into a new career path for thousands of poor but technically creative citizens. Roman 21. It also proved to be a powerful means of mobilizing capital for investment in new technologies and their commercialization into new products and services for society. That patents could be used as tradable assets by non-practicing entities without the wealth to commercialize their own discoveries was a wholly unique feature of the American patent system. By 1880, 85% of all U.S. patents were licensed by their inventors, compared with 30% of British patents. Roman 22. Patent licensing, in fact, was the principal means by which new discoveries were commercialized in the decades before the early 20th century emergence of in-house corporate R&D departments. Publications such as Scientific American were founded specifically to facilitate the trade in patents, and it regularly featured lists of new and interesting patents, which commercial enterprises then licensed or purchased to use in their product development efforts. American Bell Telephone's new product pipeline, for example, operated like most others at the time. According to its 1894 annual report, the company's R&D department licensed 73 patents from outside inventors, while developing only 12 from its own employees. Thomas Blanchard was a typical inventor licenser. He was the son of a small farmer who invented and patented a mechanical tack maker in 1806 that could fabricate 500 tacks per minute, each superior to tacks made by hand. He sold the rights to his machine for $5,000, quite a sum in those days. He then invented a lathe to produce uniform gun stocks, and the patent he received for it enabled him to attract investors for the production of those gun stocks for the local Boston market. Blanchard also leased his patent rights to gun producers nationwide, as well as to manufacturers of tool handles and wheel spokes. The income he generated from patent licensing enabled him to make inventing his full-time career. He went on to invent a wood-bending machine, an upriver steamboat, and a steam wagon that was used until the introduction of railroads in the United States, and received a total of 25 patents during his career. A portrait of Thomas Blanchard. Below the image it says, "From a portrait in the possession of F.S. Blanchard, Worcester, Mass. Figure 111 Portrait of Thomas Blanchard, circa 1912, credit. Modification of work by George Iles, via Wikimedia Commons/public domain." According to a 2013 congressionally mandated Government Accountability Office (GAO) report on NPEs, history is filled with examples of successful inventors who did not develop products based on the technologies they patented. It specifically cited the case of Elias Howe, who patented a method of making a lock stitch but did not produce sewing machines. Instead, Howe licensed his patents to the Singer Company, which then deployed Howe's invention in its sewing machines. Roman 23. Patent licensing, scholars have found, was facilitated by an array of intermediaries, lawyers, venture financiers, and patent licensing agents, who lowered the transaction costs and improved the efficiency of the trade in and commercialization of patented technology, by enabling, indeed encouraging, inventors to focus on what they did best. Invention. This division of labor gave rise to the most technologically fertile period in American history. Roman 24. The positive effects of licensing. The founders' decision to foster NPEs and patent licensing proved crucial to America's rapid technological progress and economic growth. Indeed, patent records from the 19th century reveal that more than two-thirds of the great inventors of the Industrial Revolution, including Thomas Edison and Elias Howe, were NPEs who specialized in invention and licensed some or all of their patents to outside enterprises for development into new products. Roman 25. Had the United States followed the approach of older European patent systems and limited patent rights solely to inventors who made or sold products, or prevented them from licensing their patents, America might not have even had an industrial revolution. In any event, the result of this division of labor between invention and production was exactly as Adam Smith predicted. The growth of market trade and patents raised the returns to invention and encouraged a division of labor whereby technologically creative individuals increasingly specialized in their comparative advantage, invention, noted Lamoureux and Sokoloff. It was the expanded opportunities to trade in patented technologies that enabled the independent inventors of this golden age to flourish, and that stimulated the growth of inventive activity generally. The benefits of that division of labor remain visible today, embodied in the thousands of university and other NPE patents licensed by companies large and small each year, as well as by the positive U.S. balance of trade in patent licensing, estimated to be worth at least $150 billion annually as of 2006. More than 5,000 new products and 7,000 new companies have been created with the help of university NPE patents alone in the last 30 years. Roman 26 and licensors of patented technology help the United States maintain its technology leadership in critical economic sectors. A new species called patent trolls. To be sure, there is new a species of NPE known as patent trolls, who use low-quality patents to extort so-called license fees from small businesses unable to pay the cost of standing up to them in court. But their activities have nothing in common with real patent licensing. Typically, these patent owners send form letters to hundreds, or in some cases thousands, of random small businesses, claiming with little or no evidence that they are infringing their patents. These letters then demand so-called licensing fees, ranging from $1 to several thousands of dollars, to avoid a patent infringement lawsuit that could cost those businesses far more to defend against in court, even if the business owner is innocent of any infringement. Beginning in mid-2013, a torrent of bad faith demand letters began targeting small businesses, sparking wide protest. The National Federation of Independent Businesses, NFIB, and many other business groups and trade associations demanded action, and Washington responded in 2014 with several pieces of proposed reform legislation. By early 2015, the Federal Trade Commission, FTC, had acted against one sender of bad faith demand letters, and federal legislation to rein in such abuses seemed likely to pass. At the state level, meanwhile, by early 2015, 15 states had enacted laws to curb abusive patent demand letters, and 11 others were actively considering similar bills. In addition, the attorneys general of several states have used consumer protection laws against making false claims to force these patent trolls to stop sending their extortionist demand letters. These abusive patent litigants should not be confused with legitimate NPEs, however, whose primary business is invention and technology licensing, not extorting so-called license fees from innocent businesses. Patent licensing facilitates the transfer and commercialization of technology into new products and services and promotes U.S. economic growth. A patent system for everyone. In sum, these 6 unique features of the U.S. patent system: low fees, simplified procedures, examination of applications by trained experts, systematic disclosure of new technological knowledge, lack of working requirements, and encouragement of robust trade in patent rights, all had a powerfully beneficial impact on the nation's economic growth. But none of that would have been possible were it not for the broad-based democratic rule of law in the United States, and the critical role played by the U.S. legal system in interpreting and enforcing America's revolutionary patent laws. Learning objectives. After completing this section, you will be able to describe the differences between U.S. and European patent laws, describe the history of patent litigation in the United States, U.S. patent law versus European patent law. Just as with any other property right, patent rights would be meaningless without the ability to enforce them in court. And from the earliest days of the patent system, says Kahn, our legal system remained true to the Constitution in the belief that the defense of rights in patented invention was important in fostering industrial and economic development. In Britain and other European countries, patents were viewed as pernicious monopolies that restricted community rights and had to be carefully monitored and narrowly construed. Roman 27, the enforcement and interpretation of patent laws by the courts in Europe also tended to be highly variable and dependent upon the whims of each individual judge. In the United States, however, early courts treated inventors' patent rights with deference, just as they did the rights of other property owners. Famed Supreme Court Justice Joseph Story repeatedly declared that patent rights were sacred and were the just reward for inventive ingenuity. As he noted in Lowell v. Lewis, 1817, the proper duty of the court is to ensure that wrongdoers may not reap the fruits of the labor and genius of other men. The relative uniformity and certainty of enforcement of patent rights by the courts also proved critical in encouraging capital to invest in commercializing those patent rights. Contrasting the patent laws and policies of the United States and Britain, Supreme Court Justice Henry Baldwin went to some lengths in Whitney v. Emmett, 1831, to show how English courts saw patents as a zero-sum trade-off between private rights and the public good. The explicit intention of U.S. patent law, however, was to benefit the inventor, in the belief that maximizing individual welfare leads to maximum social welfare. Nonetheless, U.S. intellectual property laws did try to strike a balance between the needs of the many and the few. Patent laws ensured the security of private property rights in invention. However, it was also necessary to balance the just claims of inventors against the dangers of exclusive monopolies that might restrict the scope of current and future invention. Roman 28. Changes in U.S. patent law through the years. Over the years, of course, that balance has moved back and forth between relatively stronger versus weaker enforcement of patent rights. With the rise of the robber barons in the late 19th century, government and the courts increasingly viewed patents through the prism of antitrust, in some cases even compelling large firms like IBM to license their patents to competitors. Then, with the advent of the high-tech revolution in the 1980s, antitrust concerns faded, and the courts began once again to view stronger patent rights as helpful in fostering innovation. Interestingly, the U.S. legal system has always operated on the theory that the best way to achieve the proper balance between private rights and public interest was not through government decree, centralized management, or compulsory licensing, but rather through the decentralized decision-making and market interactions of inventors themselves. The court's role was to resolve the inevitable conflicts that arose on a case-by-case basis. Throughout all the twists and turns in patent enforcement over the centuries, however, the federal courts have remained unwavering on four key principles of U.S. patent law. An explosion of patent litigation. Patent litigation, of course, has always been an integral feature of the U.S. patent system. The first patent case on record was that of Benjamin Folger, whose patent for the production of candles was invalidated by the District Federal Court for New York in 1792. This was merely the first of many hundreds, and eventually thousands of cases in which patent litigation served the important function of settling either the validity or the disputed ownership of the rights to critical new technologies. The litigation between telephone inventors Alexander Graham Bell and Elisha Gray being perhaps the most famous case in point. By doing so, the courts provided greater certainty regarding the value of such rights to entrepreneurs and investors alike. Today, some critics contend that an explosion of patent litigation, unlike any in history, is harming business and diverting resources better spent on innovation. No responsible observer would deny that the courts have seen an increase in patent infringement suits in recent years, just as they have seen a rise in personal injury claims and product liability suits. But that said, the evidence shows that the rate of patent litigation today is actually below historical norms. According to U.S. courts, Gov figures, the number of patent infringement suits filed in the United States increased 59% between 2001 and 2011, from 2,520 cases in 2001 to 4,015 cases in 2011. Meanwhile, the number of patents granted in that same period increased by only 35%, which supports the view that patent litigation has become more frequent over the last decade, as the role and value of intellectual property has increased in the knowledge economy. A portion of a patent document superimposed on top of another. The top portion reads Elisha Gray, Figure 1. 12. A comparison of the illustration of the telephone in Alexander Graham Bell's diaries and Elisha Gray's patent application. Credit, modification of work by Elisha Gray and Alexander Graham Bell via Wikimedia Commons/public domain. Statistics from U.S. courts. Gov show an even sharper rise in the number of patent suits filed in 2012 to 5,189 cases. But analysts attribute most of this increase to the anti-joinder provisions of the Patent Act of 2011, which curtailed the practice of naming multiple defendants in a single infringement suit. According to Carla Ridholm of the patent analytics firm Lex Machina, plaintiffs must now meet more stringent requirements to file a case against multiple defendants. So instead of Plaintiff X filing one case naming 20 defendants, Plaintiff X might file 20 lawsuits, one per defendant, each with unique civil action numbers. When looked at over the longer term, however, it turns out that 96% of all the increase in patent infringement suits since 1991 can be explained by a corresponding increase in patents granted, reports the PricewaterhouseCoopers's 2013 patent litigation study. Roman 29. In case you're wondering if the increase in patents granted is itself a sign of a patent system being increasingly gamed by speculators wanting to cash in on the new patent gold rush. Note that the average number of patents issued per $1 billion of GDP has remained at or below the same level, 13 patents per $1 billion of GDP, since 1963. XXX. Interestingly, although the number of suits filed has increased in rough correlation to patent grants, the number that actually go to trial has remained fairly constant over the last 30 years. About 90% of the suits filed each year are abandoned or settled. Of the 300 that remain, 2/3 never go to trial and are adjudicated on summary judgment of non-infringement in most cases. The nation is thus left with, at most, between 90 and 112 patent infringement trials per year. Exactly the same number that went to trial 10, 20, and even 30 years ago. Roman 31. To be sure, there can be significant costs to business even in litigating and settling patent suits that never go to trial. But no one has shown that the relative cost of patent litigation today is higher than it was historically, or that the cost of patent litigation is more burdensome than other customary legal costs in business, especially the huge cost of regulatory compliance. The evidence does not suggest that patent litigation is out of control today. As retired Chief Judge Paul Mitchell of the U.S. Court of Appeals for the Federal Circuit, the main court for patent appeals since 1982, notes, the level of patent litigation today is rather modest for a nation with 2 million active patents and hundreds of thousands of businesses competing against each other. History supports Judge Mitchell on this point. The estimated 124-plus smartphone patent suits filed between 2009 and 2012 XXA are less than 1/4 the number of patent suits filed during the first telephone wars of Alexander Graham Bell's time. Back then, the American Bell Telephone Company and its successor, AT&T, litigated 587 patent cases alone. Roman 33. Even more surprising, given the common belief in a patent litigation explosion today, patent and legal records from the golden age of invention during the mid-19th century U.S. Industrial Revolution show that the patent litigation rate at that time, defined as the number of patent suits filed in a decade divided by the number of patents issued in that decade, reached 36%. Roman 34. In contrast, U.S. courts. Gov figures show the patent litigation rate during the decade 2001 to 2011 was less than half that, only 152%. From 2002 to 2012, reflecting the increased suits, but also the increased 276,788 patents issued, the litigation rate was 157%. Over the entire period from 1790 to 1860, the patent litigation rate averaged 165%. Today's smartphone wars, then, are simply back to the future when it comes to the ways in which disruptive new industries are developed. Historians have noted that every major industrial breakthrough of the last 150 years, from the development of the sewing machine, telephone, automobile, radio, aircraft, medical stent, and even disposable diaper industries, to the birth of the semiconductor and internet e-commerce industries, witnessed exactly the same surge in patenting and patent litigation that we see in today's smartphone field. Roman 35. And just as with smartphones today, the most competitive technology arenas have always been the most litigious. In Edison's time, the inventors of electrical discoveries were 4 times more likely than other inventors to be involved in patent litigation, and accounted for 41% of all patent suits filed during that period. Roman 36. In any event, by early 2015, it had already become clear that a noticeable decline in patent litigation was underway. Most analysts attributed the decline to a series of U.S. Supreme Court rulings in 2014 limiting the patentability of software and increasing the ability of the courts to impose sanctions on abusive litigants, which will be discussed later in this chapter. Also driving this decline in litigation was the availability of new post-grant review proceedings under the New America Invents Act, which allow third parties to challenge patents and, if the evidence so warrants, have their claims invalidated by the USPTO's patent trial and appeal board. Although patent litigation is costly, the historical record suggests that it serves a vital function by settling the validity and disputed ownership of patent rights, so these can be commercialized into new products, new services, and new medical treatments. This is, in fact, the proper role of the courts. Learning objectives. After completing this section, you will be able to explain the effects of the U.S. patent system on American economic development, describe trends in U.S. patenting over the years, creating the world's most successful economy. In 1630, the Puritan John Winthrop, future governor of Massachusetts colony, declared that we shall be as a city upon a hill, the eyes of all people are upon us. 150 years later, the founders of the United States of America proved Winthrop right, offering the world a vision of liberty and democratic governance that continues to inspire people to this day. As noted previously, the men who led the revolution and wrote the Constitution were not wild-eyed revolutionaries. They were eminently practical people who managed to create the longest living modern democratic political and economic system on the planet. In other words, they must have done something right. And one of those things was surely the patent system they created. Because almost from the moment of its inception, it began to spark innovation and economic growth on a scope and scale never before seen in the world. Only 2 months after America's first patent law was signed in 1790. In fact, Thomas Jefferson himself noted that it had given a spring to invention beyond my conception. Within 13 years, America surpassed Britain. Until then, the unrivaled leader of the Industrial Revolution, in the number of new inventions patented, even though Britain still had more than twice America's population. By 1870, as noted earlier, the United States was patenting more than 5 times the number of inventions as Britain, although their populations were by then roughly equal in size. At first, most British observers were dismissive of American innovation efforts, declaring that the former colony would never be able to progress beyond the simple imitation of superior European technologies. But eventually, Britain and other nations took note of the way the U.S. patent system seemed to be stimulating invention and economic growth at an unheard-of pace. Photograph of William Thomson, Lord Kelvin, Figure 1. 13 Photograph of William Thomson, Lord Kelvin. Credit, modification of photo by Messrs. Dickinson, London, New Bond Street, according to http://www. sil. c. edu/digital collections /hsd/scientific identity /full size /sil 14t00 2-07a. JPG via Wikimedia Commons /public domain. Sir William Thomson, pictured above. A British inventor and scientist attending the 1876 Centennial Exhibition in Philadelphia looked at the amazing array of American inventions, including Bell's telephone, the Westinghouse airbrake, Singer's sewing machines, and Edison's improved telegraph, and had this to say: "If Europe does not amend its patent laws, America will speedily become the nursery of useful inventions for the world." Roman 37. Meanwhile, the Swiss commissioner in attendance, the shoe manufacturer Edward Bally, offered a similar warning to his Old World countrymen. American industry has taken a lead which in a few years may cause Europe to feel its consequences in a very marked degree. Then there's Japan's Assistant Secretary of State Korkio Takahashi, who visited the U.S. Patent Office. Upon his return home, he said, "What is it that makes the United States such a great nation? We investigated, and we found it was patents, and we will have patents." Even the British jurist Sir Henry Sumner Maine, who had once argued that the establishment of the masses in power is the blackest omen for the future of invention, later changed his tune. He conceded that the U.S. patent system was one of the provisions of the Constitution that have most influenced the destinies of the American people, and that it had made the United States the first in the world for the number and ingenuity of its inventors. Roman 38. As historians Lamoureux and Sokoloff noted, foreign observers attributed much of the country's rapid technological progress to its distinctive patent system. Quite revolutionary in design at inception, the U.S. patent system came to be much admired for providing broad access to property rights in new technological knowledge and for facilitating trade in patented technologies. These features attracted the technologically creative, even those who lack the capital to directly exploit commercialize their inventions, and also fostered a division of labor between the conduct of inventive activity and the application of technical discoveries to actual production. It is no coincidence that Britain and many other European countries later began to modify their patent institutions to make them more like those of the Americans. Roman 39. Every breakthrough spurs patenting spikes. The patent system's central role in fostering innovation can be seen in the patenting spikes that occur with every major industrial breakthrough. A major surge in patenting took place in the 1880s. For example, when the number of new patents issued each year jumped 56% to about 20,000, compared with the 12,000 issued yearly during the previous decade. This patent boom corresponded with rapid advances in the emerging railroad, telegraph, telephone, and electric light and power industries that signaled the industrialization of the U.S. economy. The next sharp surge in patent issuances began around 1902 and lasted until 1916 or so, when the number of patents granted doubled from 20,000 per year to around 40,000 per year. This was the period of the newborn automobile and aircraft industries, most rapid early-stage growth. Patenting levels then remained relatively stable at about 40,000 per year until around 1960 or so, when the revolution in plastics and other synthetic materials, along with boom-time growth in the aerospace and computer industries, pushed patenting levels to 60,000 per year. There they remained until the mid-1980s, when the personal computer and emerging high-tech industries of Silicon Valley began to power the whole of the U.S. economy and propel us toward the age of the Internet. Patenting levels then rose to around 80,000 to 100,000 yearly. With the rise of the Internet, social media, mobile telephony, and smartphones over the last 2 decades, the number of patent applications filed each year with the U.S. Patent and Trademark Office, USPTO, has surged fourfold. In 2014, the USPTO received 578,802 applications, finding 300,678 of these applications worthy of receiving a patent. This is but the latest spike in innovation and patenting. Patent USPTO number 2,956,845, drawing, page 1, 13, showing an axial piston pump, type swash plate, with spherical-shaped piston heads and piston ring. Figure 1, 14 USPTO patent number 2,956,845 for an axial piston pump. Credit: modification of work by Gunnar A. Wallmark, Rockford, Illinois, USA. Via Wikimedia Commons/public domain. Clearly, whenever the United States has undergone a major industrial renaissance, during which technology advances lead not only to the birth of new industries, but also to the reshaping of existing ones, patenting levels rise dramatically. It is no surprise, therefore, that Silicon Valley, midwife of many of the new knowledge economy industries of the past 60 years, is home to less than 1% of the nation's population, but earns 12% of its patents each year. The Valley is now the site of a new USPTO satellite office serving high-tech innovators there. Excel. The patent system has also been crucial in facilitating the growth of new startup businesses, with 67% of entrepreneurs reporting that they find patents valuable in obtaining venture financing. Roman 41. This is important because, although large companies contribute enormously to American innovation and industrial growth through their in-house research and development operations, as well as via their partnerships with research universities, startup companies play a particularly strong role in the creation of entirely new industries. Indeed, virtually every innovative new industry of the last 150 years, from the telegraph, telephone, and electric power industries of the 1800s to the auto, aircraft materials, and aerospace industries of the 20th century to the semiconductor, personal computer, software, biotech, and internet e-commerce industries of the last 60 years, was launched by an entrepreneurial startup company. The founders would not be surprised by this, They created the world's first democratized patent system, after all, for a reason: to stimulate the ingenuity of the common man. They had asked themselves a question. The same question reiterated 2 generations later by Supreme Court Justice Joseph Story when he spoke before an audience of ordinary mechanics. Ask yourselves, what would be the result of 100,000 minds, urged on by the daily motives of interest, to acquire new skill or invent new improvements? Roman 42. The result was the most successful economy on the face of the earth. Patents and the American dream. It's not only the economy that the patent system helped shape, but the culture and consciousness as well. As the eminent historian Gordon S. Wood observed in his 2010 book Empire of Liberty, by the early 19th century, technology and prosperity were assuming for Americans the same sublime and moral significance that the Enlightenment had reserved for the classical state and the Newtonian universe. Eli Whitney, inventor of the cotton gin, and Robert Fulton, creator of the steamboat, became national heroes. And for the first time in human history, a nation had come to see its greatness not in empire or military might or royal lineage, but in its capacity for technological progress. There was nothing preordained about America's economic success, no special Yankee ingenuity gene in their hereditary stock. As Scientific American noted in 1876, the United States advanced, not because we are by nature more inventive than other men. Every nationality becomes inventive the moment it comes under our laws. Rather, the secret of America's success was a uniquely democratic patent system that added the fuel of interest to the fire of genius in generations of ordinary citizens, and in so doing, helped in a very real way to give birth to the American dream itself. Ironically, few people today even know the origin of the term, the American dream. In fact, it was coined in 1931 by the historian James Truslow Adams in his book Epic of America, and it is instructive to read what Adams meant by it. The American dream, that has lured tens of millions of all nations to our shores in the past century, has not been a dream merely of material plenty, though that has doubtless counted heavily. It has been much more than that. It has been a dream of being able to grow to fullest development as a man and woman, unhampered by the barriers which had slowly been erected in the older civilizations, unrepressed by social orders which had developed for the benefit of classes rather than for the simple human being of any and every class. Only in America could a working-class youth named Thomas Edison, with less than 3 years of schooling, develop himself into the world's greatest inventor. A visionary who gave the world some of the most important technologies of late 19th and early 20th century life. This is exactly what the founders had in mind when they created the U.S. patent system. Portion of a sewing machine patent drawing showing a wheel, axles, and connecting rods. Figure 115 USPTO patent number 326,821 for a sewing machine. Credit: USPTO via Wikimedia Commons/public domain. Learning objectives. After completing this section, you will be able to identify the characteristics of a patentable invention, understand what is not patentable and why. What exactly can you patent? Title 35 of the United States Code, the Patent Act, allows anyone who invents or discovers any new, non-obvious, and useful machine, manufacture, process, or composition of matter, or who makes an improvement of any of the above, to obtain a patent. Roman 43. These 4 kinds of patentable inventions fall into one of 2 categories. They are products or processes. Roman 44. Product or process. Products are physical things, whether they be machines, a new type of robotic welder, manufactures, an artificial knee made of titanium, or compositions of matter, a new chemical superglue for binding materials together. In this photo, Elon Musk observes the robotic arms in the Tesla Motors factory. Specialized manufacturing equipment like this are patentable products. Processes or methods, on the other hand, are a means to an end, either a means of doing something new, being able to pay for purchases directly from your smartphone, or a new way of doing something old, using pinch, swipe, and zoom gestures on a touchscreen rather than clicking drop-down menus to manipulate text, music, and images on a smartphone. You cannot patent ideas. All patented inventions fit into one of these 4 categories: machine, manufacture, process, or composition of matter. but not everything that fits in one of these four categories can be patented. And the most important reason why one thing is patentable and another is not lies in the difference between ideas and applications. You cannot patent an idea for a better mousetrap, not unless it can be developed into a new, non-obvious, and useful machine, manufacture, process, or composition of matter that can actually accomplish the task. You may have a genius idea for faster-than-light travel, but that will not get you a patent unless you can outline how to develop a tangible process or device for actually doing so, in which case you can seek to patent it. Put another way, talk is cheap when it comes to securing a patent. The U.S. Patent and Trademark Office offers no judgment as to the wisdom or desirability of any particular invention. Patent No. 2,880,2,858 for a bird diaper is certainly proof of that. But it absolutely will insist that every invention include a tangible device or process for achieving its intended purpose before it deems the invention worthy of a patent. Mathematical formulas not patentable. There are other discoveries that fall into the broad category of abstract ideas and are thus unpatentable. You cannot patent a mathematical formula. You cannot patent a law of nature, such as Einstein's E equals mc2. And you cannot patent natural phenomena like electricity, discovered by William Gilbert in 1600, or the Higgs particle that gives all matter its mass, discovered by researchers at the Large Hadron Collider on July 4, 2012. These all exist independently of human intervention, whether we have discovered them or formulated their rules yet or not, and must be freely available to all of humanity for its understanding and betterment. To restate the distinction, you cannot patent electromagnetism, but you can patent a telegraph that uses electromagnetism to communicate rapidly over great distances, as Samuel Morse did in 1840 with Patent No. 1647. And although you cannot patent light waves, you can patent a fiber optic wire that employs light waves to communicate even more rapidly and over greater distances, as Corning glass researchers did in 1970 with Patent No. 3,711,262. A photo of a portion of the Large Hadron Collider. It features a very large circular assembly of devices connected with cables. Figure 1. 16 portion of the Large Hadron Collider. Credit, photograph by Luigi Selmi via Flickr/CC by 20. Can you patent computer software? The boundary between ideas and applications might seem clear, but it has become blurred since the advent of computer technology 40 years ago, especially regarding the patentability of software. To learn more, watch this video from PBS Digital Studios about the first software patent ever awarded, and to learn a bit about the debate around software patentability. Mixed verdicts on software patentability. The federal courts and the U.S. Supreme Court have tried to clarify the limits of patentability in the computer age. 3 Supreme Court cases in particular, often called the patent eligibility trilogy, reveal the evolution of its thinking about software patentability. In 1972, the Supreme Court held in Gottschalk v. Benson that an algorithm in a computer program, in this case, a mathematical procedure executed electronically that was similar to long division with paper and pencil, was in and of itself not patentable. Phenomena of nature, mental processes, and abstract intellectual concepts are the basic tools of scientific and technical research, the court noted, and therefore could not be patented lest it foreclose others from using the algorithm and thereby stifle rather than promote technological progress. Granting a patent in this case, the court said, would be analogous to having granted Samuel Morse a patent covering all possible uses of electromagnetism in communications, rather than for the specific method and apparatus he actually invented. The court made a point of saying, however, that its decision did not mean that computer software could not be patented. Only that software whose only useful characteristic was an abstract algorithm could not be patented. The Supreme Court further refined its thinking on software patentability in the 1978 case Parker v. Fluke. Unlike the attempt to patent all uses of an algorithm in the Benson case, here the use of a software algorithm was limited to a specific application, setting off an alarm during the catalytic chemical conversion of hydrocarbons. This was a specific and tangible use of an algorithm, but the court still ruled the software unpatentable because it felt the application itself was not inventive. But once again, the court left the door open. Even though a phenomenon of nature or mathematical formula may be well known, an inventive application may be patented. 3 years later, the Supreme Court made its third attempt to define the patent-eligibility of software. In Diamond v. Deere, the court ruled that although algorithms by themselves are not patentable, a software program that used algorithms to govern the molding of raw synthetic rubber into cured precision products was in fact patentable because it involved transforming or reducing an article to a different state or thing. The software picture blurs even more. Taken together, the three rulings appeared for a time to arrive finally at a coherent definition of software patentability. Namely, that although algorithms by themselves are abstract concepts and therefore unpatentable, software programs may be patented if they employ algorithms to produce a tangible and inventive or transformative result. This view was further augmented by a 1998 U.S. Court of Appeals for the Federal Circuit decision in State Street Bank v. Signature Financial Group, which extended software patentability to software-enabled methods of doing business, so long as these produced a useful, concrete, and tangible result. But this definitional equilibrium was not to last. The useful, concrete, and tangible result test in State Street Bank was rejected 10 years later by the same court in Ray-Bilski, which upheld the USPTO's denial of a patent for a method of hedging risk in commodities trading. The court instead offered a machine or transformation test, which allows a software program or business method to be patented only if it is implemented on a specific machine to achieve a special purpose that is novel, non-obvious, and useful. It transforms an article from one thing or state to another. But in its review of Bilski v. Capos, the Supreme Court ruled that while the machine or transformation test was useful, it was not the only test for patentability. In addition to the machine or transformation test, the court decreed, rather vaguely, that any future test should be grounded in the examples and concepts expressed in its original patent-eligibility trilogy of opinions. They thus reaffirmed that business methods may indeed be patentable. Finally, a pretty clear message. While businesses and the courts were trying to figure out what the other tests for patentability might be, the Supreme Court provided further input with its March 2012 decision in Mayo Collaborative Services v. Prometheus Laboratories. Here, the court ruled that a process enabling physicians to correlate blood test results with medication levels to achieve the most appropriate dosages was ineligible for patent protection. But then, in June of 2014, the Supreme Court issued what may prove to be its most consequential decision on the patentability of software in the 33 years since Diamond v. Deere. In Alice v. CLS Bank, the court ruled that taking some activity that people have been doing for centuries, in this case, holding funds in escrow until a transaction is completed, and then merely doing it through a computer, did not turn this age-old activity into a patentable new invention. At first, many observers believed that the effects of the Alice v. CLS Bank ruling would be very limited. Only the patent in the suit was invalidated, after all, not all software patents. What's more, the abstract reasoning of the court in its decision did not provide clarity on how the ruling may or may not apply to other kinds of software patents. For example, the sort of software used in manufacturing that was ruled patentable in the 1981 Diamond v. Deere case. But by October of 2014, a series of lower court decisions applying the new Alice v. CLS Bank standard had invalidated 13 additional software patents. As technology policy journalist Timothy B. Lee noted, the courts are sending a pretty clear message. You can't take a commonplace human activity, do it with a computer, and call that a patentable invention. The courts are sending a pretty clear message. You can't take a commonplace human activity, do it with a computer, and call that a patentable invention. Timothy B. Lee, technology policy journalist. How far-reaching will the impact of Alice v. CLS Bank be? This doesn't necessarily mean that all software patents are in danger, Lee noted, because the patents involved were particularly vulnerable to challenge under the new Alice precedent. But it does mean that the pendulum of patent law is clearly swinging in an anti-software, patent direction. Overcoming the Alice paradox, By late 2015, however, it was clear that the Alice ruling was having an impact not only on patent law, but also on the innovation process itself within corporate America. As John Cronin, a former top inventor at IBM and now the CEO of the innovation-on-demand firm IP Create, observes, the highest value products and services today, the ones that increasingly drive margins in business, involve cloud computing, big data, machine learning, connectivity, mobility and location-based services, and on-demand and anything-as-a-service software applications and business processes. But ironically, these high-value innovations are also the most difficult to patent nowadays as a result of the Supreme Court's Alice decision. Cronin calls this the Alice paradox, and it has left many in-house patent groups struggling for a solution. One thing is clear. To be patentable nowadays, software has to take a genuinely inventive step and either trigger an action, employ a device, or in some other way produce a tangible, transformative result. In addition, smart companies are trying to address patentability issues involving software and business processes much earlier in the innovation cycle, before huge investments are made in R&D that may turn out to be not patentable. Overall, addressing the Alice paradox will be critical for many companies because patenting clearly adds value to a new product or service. In a groundbreaking joint study from Carnegie Mellon University, Georgia Institute of Technology, and Duke University entitled R&D and the Patent Premium, economists found that the patent premium for innovations that were patented is substantial. Firms earn on average a 50% premium over the no patenting case, ranging from 60% in the health-related industries to 40% in electronics. Roman 45. The debate on software continues. The debate over the dividing line between patentable versus unpatentable computer software-related inventions continues in corporate R&D labs and in the courts. However, there are some who don't believe that software and business methods should be patented under any conditions. They argue first of all that software is different from other industries, more iterative and more incremental, with each advance building upon thousands of previous advances. Therefore, their thinking goes, software should not be entitled to patents that ought to be more properly reserved for truly breakthrough or revolutionary inventions. There are two problems with this argument. First, as anyone in the semiconductor, chemical, or medical device industries can attest, innovation is no more iterative, incremental, or cumulative in software than is innovation in many other industries. Indeed, there are probably just as many or more patents for incremental semiconductor inventions that build modestly upon earlier work as there are patents for incremental software inventions that do the same. Two computer mouse devices from Apple are pictured side by side. The older one is a rectangle with a button and a wire. The newer one is oval and much more smooth, with no buttons and no wires. Figure 1. 17. An Apple Macintosh Mouse M100 beige from 1984 left, and an Apple Magic Mouse from 2009 right. Credit. Photograph by Renico via Flickr/CC by 2. 0. As patent scholar and veteran practitioner Paul Janik of the University of Houston put it, there really are no breakthrough inventions, at least not in the sense imagined by these critics. Everything moves one step at a time. In fact, every time I thought I encountered a large leap, it turned out that I didn't know the full extent of the prior art. The second problem with their logic is that the Founding Fathers specifically designed the patent system to encourage precisely this kind of incremental invention, so that ordinary people, using only the basic technical skills possessed by most citizens, could participate in rapidly developing the economy from the ground up. This was a very different approach than that of elitist European patent systems of the day, and it produced results that the rest of the world very soon came to envy. See Section 1.5. What the U.S. patent system wrought. As the October 21, 1876, issue of Scientific American noted, in the aggregate the little things, which in England or the continent would not or could not be patented, probably add more to the wealth and well-being of the community than the great things do. Or, to quote Thomas Jefferson himself, a smaller invention, applicable to our daily concerns, is infinitely more valuable than the greatest which can only be used for great objects. Roman 46. Any uncertainty over the validity of incremental patenting was removed once and for all by the Patent Act of 1952. Consistent with the founders' intentions, U.S. law now explicitly holds that patent eligibility is not restricted solely to revolutionary inventions or flash of genius discoveries, but also includes more iterative advances in the state of the technological art, so long as these meet the requisite novelty, non-obviousness, and utility criteria. Evidence shows software patents don't hinder innovation. Another argument made by critics of software patenting is that patents stifle innovation and foster monopolization in the software industry. Research, however, suggests that this is decidedly not the case. Roman 47. If anything, in fact, the software industry has become even more innovative, more diversified, and more startup-friendly since patenting became common in the 1990s. You need only look at the huge proliferation of highly innovative startups in today's social media and app software fields to see just how erroneous the claim is that software patents stifle innovation. Or consider for a moment the fate of the BlackBerry, once dominant, but within the space of a couple of years, superseded by more innovative competing smartphone makers. Finally, some critics insist that the intangible nature of software ought to disqualify it from patentability. But as noted earlier, the Supreme Court has affirmed repeatedly that although abstract concepts cannot be patented, software that employs algorithms to produce a tangible and inventive result, e.g., software that governs the molding of raw synthetic rubber into cured precision products, may be patented. It's also helpful to view this issue in a larger context. 40 years ago, 80% of the market value of all public companies resided in their tangible physical assets, their plant, equipment, and raw materials. In today's knowledge economy, however, it is intangible assets, intellectual property, that make up 80% of the market value of public companies. Roman 48. Indeed, the entire history of economic progress on our planet may be described as one long climb by humanity up the ladder of abstraction. From brute force to the subtle use of energy. From wealth derived from tangible resources and industrial machinery to wealth derived from ever more ingenious ways to deploy that energy and those resources. It seems only logical, therefore, to expect that invention itself should follow a similar trajectory, from the realm of the tangible to the realm of the intangible. Ironically, the debate over patents for software, business methods, and other intangible inventions is nowhere more heated than on the internet, itself an intangible realm in which virtual businesses launched with little more than hope and electrons, e.g., Facebook, are creating real and substantial wealth in the form of new products, new services, new jobs, and new economic growth for society. Yet, strangely, those who have no trouble accepting the internet as the intangible fruit of information age invention seem to get stuck in industrial age conceptions of what should and should not be patentable. Odd perhaps, but not surprising. The expansion of patentable subject matter into new and more intangible realms has always met with resistance. Patents involving the use of electricity were condemned 140 years ago, as were biotechnology patents 30 years ago, and of course software patents when they began to appear in large numbers 20 years ago. In each case, critics warned that these new kinds of patents would hold back further scientific discovery and innovation. Yet in each case, innovation and discovery actually intensified, and their benefits to society multiplied. When gene-related inventions are patentable, a similar resistance is also developing toward gene-related patents. These began to be issued in significant numbers after the Supreme Court's 1980 ruling in Diamond v. Chakrabarty, which upheld the first patent on a newly created living organism, a bacterium for digesting crude oil in oil spills. Since then, patents have been granted for isolated gene sequences, but so far only on those with known functions and not on naturally occurring genes in humans or other organisms. Patents have also been granted for gene sequences used in diagnostic testing, and on gene sequences that have been altered to make them more useful in a specific application. In March of 2010, however, a federal district court judge ruled in the case of Myriad Genetics that even isolated DNA is fundamentally the same as naturally occurring DNA, and is therefore ineligible for patenting. His ruling was reversed by the U.S. Court of Appeals for the Federal Circuit in July 2011. But the Supreme Court then set aside that decision and directed the appeals court to once again review the case in light of its March 2012 Prometheus decision. On August 16, 2012, however, the U.S. Court of Appeals for the Federal Circuit once again reaffirmed Myriad's right to patent the isolated genes BCRA1 and BCRA2, which are involved in most inherited forms of breast and ovarian cancer. On June 13, 2013, however, the U.S. Supreme Court finally determined in a unanimous decision that a naturally occurring DNA segment is a product of nature and cannot be patented merely because it has been isolated, thereby invalidating Myriad's patents on the BRCA1 and BRCA2 genes. The court did rule, however, that the manipulation of a gene to create something not found in nature, such as a strand of synthetically produced complementary DNA, cDNA, could still be eligible for patent protection. To the average citizen, and perhaps to many patent lawyers as well, all this legal hair-splitting over the limits of patentability in the computer age must seem a bit like the debates in medieval times over how many angels can dance on the head of a pin. But two critical points must be borne in mind regarding these debates. First, no matter what anyone thinks the limits of patentability in an ideal world ought to be, out in the real world where we actually live, software, business method, and gene patents are multi-billion-dollar facts of life that businesses ignore only at their peril. Second, whatever confusion may exist today, the debates over patentability in the computer age will almost certainly be resolved eventually to most people's satisfaction, just as all previous debates over patentability have. For if nothing else, the 200-year-plus history of the courts and the Patent Office demonstrate a remarkable ability on the part of these institutions to adapt to the challenges posed by new technologies and new economic conditions. Learning objectives. After completing this section, you will be able to identify the criteria that an invention must meet to earn a patent. Understand why non-obviousness is the most difficult hurdle to overcome. Can I patent that? Before reading this section, please watch the overview video below covering what you can and cannot patent. You can't patent an idea, like an idea for a better mousetrap. Only an application of that idea in a practical invention. Novelty, utility, and non-obviousness, the holy trinity of patents. Now that you've learned what can be patented and what cannot, we will next examine the criteria for determining if a patent-eligible invention actually merits one. These criteria center around three concepts mentioned in the previous section and enumerated in the Patent Act: novelty, utility, and non-obviousness. Roman 49. Let's discuss these three concepts in greater detail. Novelty. The requirement in sections 101 and 102 of the Patent Act for novelty in an invention means that to qualify for a patent, a machine, manufacture, process, or composition of matter must not have been previously described or known. Specifically, it must not have been patented, described in an unpublished or published patent application, explained in a printed publication such as an article or technical paper, or publicly known prior to the filing date of the new patent application. In addition, it must not have been published, used in public, or offered for sale by the applicant or their colleagues more than 12 months prior to the filing of a patent application. An image of a patent for dog ear protectors. They are cylinders that go around a dog's ears to keep the hair from dangling down. The text indicates that they are designed to keep a dog's hair clean while eating. Figure 1. 18 patent for dog ear protectors designed to keep a dog's hair clean while eating. Credit, USPTO via USPTO, gov/public domain. If any of the above is true of an invention, it is said to have been anticipated and cannot be patented. These novelty requirements exist whether the prior art, the catch-all term for any previous patent, publication, or use, is domestic or foreign. This does not mean, of course, that your faster-than-light warp drive is unpatentable simply because it was envisioned in a general way in episodes of Star Trek and its successors, television shows, and in many Star Trek books. It is not enough that an invention be suggested by the literature, explains the eminent New York University scholar Arthur R. Miller and his co-author Michael H. Davis in their textbook for law students. Nor is it sufficient that the literature made the invention inevitable. That bears on the question of non-obviousness. The test, with one major exception, is whether enough of the invention has been disclosed to enable a person skilled in the applicable art to duplicate the product or process. That one exception, writes Miller and Davis, is public use of the invention. In that case, even a limited disclosure that does not reveal the secrets of the invention can still foreclose a patent if the public use of it discloses the invention's benefits. Prior art must be enabling. In the era of social media, the previously mentioned requirements could pose a novelty barrier if not handled properly. For instance, if you develop a new watch that displays information from an iPhone, and then disclose it on the crowdsourced funding site Kickstarter in order to raise capital from thousands of small-time investors, then you will probably want to file a patent application prior to, or certainly no later than a year after, your disclosure of the benefits of your watch to the public. But in the absence of such public use, disclosure in prior art must be substantial and enabling to be disqualifying. As patent attorney and writer of the widely read IP watchdog blog, Gene Quinn explains, what Star Trek teaches is the idea of warp speed wit, some suggested articulation of how it could be achieved. But that's not informing enough. Someone could not make and use the device based on what is taught in Star Trek. So if you actually figure out how to make a faster-than-light warp drive work and can describe it sufficiently so that someone skilled in the science of space propulsion could build it, then yes, it would be patentable. Take heart, Star Trek fans, utility. As the Star Trek example suggests, the novelty issue can also touch on the question of utility, the second patentability criteria. Utility has a special meaning in patent law, which is simply that an invention must function and be of some benefit qualitatively, although no minimum quantum of benefit is necessary. The landscape of business is littered with companies that have invented not very useful or necessary products, but these may satisfy the requirement for utility if at least someone would find them useful. But snake oil medicines and other products that do not work in any meaningful way will not meet the requirement for utility. The inventor of an ineffective drug may not obtain a patent merely because he convinces gullible patients that it has a non-existent curative effect. Miller and Davis note. It is not so much that it lacks a minimum quantum of benefit. The patients may find it subjectively useful, but it is, instead, that it has an impermissible fraudulent quality. A label for Warner's famous rattlesnake oil. Figure 1, 19, an ad for Warner's famous rattlesnake oil, circa 1914. Credit, Warner's famous rattlesnake oil via Wikimedia Commons/public domain. Even when no fraud is intended, the utility of a product or process must be demonstrated in a patent application. Not presumed, but affirmatively demonstrated. Simply put, the thing or the method you have invented must actually work as it is intended and claimed to work. Forget Star Trek for a moment, says Quinn. On a more mundane level, the USPTO used to deny patents for methods and compositions for regrowing hair. These were seen as lacking utility because regrowing hair was believed to be impossible. Finally, someone was able to prove that his method and composition actually regrew hair on a bald scalp. The patent examiners withdrew their rejection, and patents for such products have issued ever since. Interestingly, Quinn explains, since the earlier patent applications on hair-growing products didn't describe anything that actually worked, they could not be used under the novelty bar to block later patent applications for hair-growing products that did work. Non-obviousness. An invention may be new. It may also have utility. But to meet the criteria for a patent, it must also be non-obvious under Section 103 of the Patent Act. Let's now dig deeper into the requirements of the concept of non-obviousness. Requirements. The requirement for non-obviousness may be illustrated with a fanciful example. If the number 4 were an invented product rather than a mathematical symbol, then even though the number 4 had never been invented before and was thus novel, it would still not be patentable. That's because someone skilled in the art could have put 2 and 2 together to come up with it. But to offer a more practical example, say you invent a wheeled cart to move office supplies more easily between departments. If this is the first such wheeled office cart in history, you can get a patent for it. But if you then decide, Hey, why not put those wheels on a chair? You won't get a patent for it. That's because combining two such widely known and available elements would be obvious to anyone skilled in the art of office furniture design. But things are not so obvious when it comes to inventing a camera phone, even though it's composed of well-known and widely available components. Combining the two did satisfy the requirement for non-obviousness, because it became more than the sum of its parts and met a large and previously unfilled need in the marketplace. The millions of people who take selfies every day is certainly proof of that. There are various ways of presenting evidence that your invention satisfies the non-obvious requirement for patentability. You can demonstrate that the existing elements of your invention, although individually already known, yield an unexpected or hidden result. Or you can show that your invention, although composed of well-known and widely available components, when combined satisfies a long-felt but previously unfilled need in the marketplace, thus indicating its non-obviousness. Both of these demonstrations of non-obviousness apply to the camera phone example above. The one-click patent. Some people criticize the so-called one-click patent granted by the USPTO to Amazon.com in 1999 for Amazon's system enabling customers to buy an item with a single click of the mouse, with the payment information needed to complete the purchase already having been entered by the user previously. They contended that, although Amazon might have been the first company to employ the process, it was an obvious and inevitable iteration of already existing mouse-clicking procedures for making a purchase online. The Patent Office re-examined the patent, however, and in 2007 upheld the validity and the bulk of its major claims. It is important to note that it's an invention's function that is often examined to determine obviousness. Even though it may be obvious that a certain object can be constructed in a certain way, its utility and novelty may lie in its functional use, not its construction. Wright, Miller, and Davis. Therefore, the prior art must be used to determine whether the invention's new and useful function, not its construction, is non-obvious. During the first half of the 20th century, the courts often saw an invention as obvious when it lacked a flash of genius, and was merely an incremental advance over the state of the art as opposed to what they imagined would be a revolutionary, breakthrough discovery. But that subjective interpretation of inventiveness was overturned by the 1952 Patent Act, which codified a more objective standard. Namely, that whether an invention is developed through laborious trial and error, or through a eureka flash of genius moment, has no bearing on its obviousness or non-obviousness. Overcoming patent hurdles. Taken together, the three patenting criteria, novelty, utility, and non-obviousness, function like the obstacles in an Olympic hurdles race. The utility hurdle is easiest to overcome, the novelty hurdle less so. But by far, the highest hurdle facing inventors is non-obviousness. The vast majority of all rejections at the Patent Office are for obviousness reasons, explains retired Chief Judge Paul Mitchell of the U.S. Court of Appeals for the Federal Circuit, the main court that handles patent appeals. And it's not very difficult to see why. Given the millions of patented inventions over the decades, the tens of millions of past and current products on the market, it's not all that easy to come up with an invention that is not only novel, but also truly non-obvious to someone with ordinary skill in the state of the art. Many believe that the criteria for patenting weakened in the late 1990s and early 2000s, and that, as a result, too many poor-quality patents were issued. To the extent this problem exists, one of its likeliest causes is the five-fold increase in patent applications that has taken place over the last 30 years without a commensurate increase in USPTO funding, resources, and capabilities. Despite these challenges, the USPTO has made substantial progress in the last 5 years in improving examiner training and tools, reducing the backlog of pending applications, and strengthening the quality of the examination process for patent applications. This progress has been made despite oftentimes unclear or contradictory patentability rulings from the courts. Patent quality is essential to the maintenance of public confidence in the patent system. After all, when property rights, either real or intellectual, are seen as overbroad, ill-defined, or illegitimate, individuals and businesses are more willing to trespass on them. A photo of many seedlings inside of a greenhouse. Figure 120, credit. Photograph by Brian Boucheron via Flickr/CC by 20. Learning objectives. After completing this section, you will be able to explain the differences among utility, plant, and design patents. Describe common patent misconceptions. Up to this point, we have focused only on the most common types of patents, called utility patents, which preclude others from making, using, or selling the invention during the term of the patent, which begins on the grant date and ends 20 years from the filing date, for an average of 17 to 18 years. But in addition to these, the Patent Act also provides for two other types of patents: plant patents and design patents. Plant patents. Plant patents were first created by the Patent Act of 1930, which had been proposed by Luther Burbank to protect new species of asexually reproduced plants, mostly flowers. These are different than the utility patents granted to bioengineered plants used in agriculture. The United States was the first country in the world to grant plant patents, and even today many countries continue to deny protection for plants. Indeed, even some signatories to the Agreement on Trade-Related Aspects of Intellectual Property Rights, TRIPS, administered by the World Trade Organization, WTO, reserve the right to deny patents for plants. Although the requirements for plant and design patents are substantially the same as those for utility patents, there are some crucial differences. The most important of these is the substitution of a different test for one of the three criteria for patentability discussed in the previous section. Instead of novelty, utility, and non-obviousness, the criteria for plant patentability are novelty, distinctiveness, and non-obviousness. To be patentable, plants must be cultivated rather than found in the wild, and plant patents are granted only to protect a new, distinct, and non-obvious variety of asexually reproduced plant. Those grown not with seeds but by grafting, budding, or cutting. A plant need not be useful to qualify for a patent, but it must be distinctive in its color, habit, soil, flavor, productivity, form, or other aspects. Design patents. Design patents are granted to protect new, original, and non-obvious ornamental designs for articles of manufacture. Examples include Apple's 2009 and 2010 patents, No. D593087 and number D618677, which covered, among other things, the unique, rounded corner design of the iPhone, as well as its 2005 design patent No. D504889 for the look and feel of the iPad. Design patents can be just as valuable as utility patents, as Apple discovered when a jury awarded it $1 billion in damages against Samsung in August 2012 for the latter's infringement of Apple's utility and design patents. The case is currently on appeal. Like plant patents, design patents also substitute a different test than utility in their requirements for patentability. Instead of the novelty, utility, and non-obvious requirements for utility patents, the criteria for design patents are novelty, ornamentality, and non-obviousness. It was on the subject of design patents that one example of media confusion appeared. The New York Times published an article November 16, 2012, declaring in a sensational headline that Apple now owns the page turn. The article claimed that a new Apple design patent gives Apple the exclusive rights to the page turn in an e-reader application. According to the article's author, this showed just how broken the patent system is. Had the author of the article even read an obvious and easily available source as the Wikipedia entry on design patents. However, he would have learned that design patents are granted only for non-functional ornamental designs. In fact, says Wikipedia, design patents can be invalidated if the design has practical utility. What Apple actually owns, therefore, is not the page turn function itself, but merely the particular ornamental design of the way a page turn is executed in their devices. Another example of confused media reporting on patent matters was the February 6, 2013 Forbes article headlined, "Is the patent system broken? Well, Amazon's just patented the sale of secondhand goods." Amazon actually did no such thing, but the author of that article probably made this assumption after reading the abstract of the patent describing its general subject matter. Like many reporters new to patent issues, the author didn't realize that the abstract tells you literally nothing about the exclusive rights conferred by a patent. Only the claims of the patent detail the specific exclusionary rights of the patent holder. Indeed, when you read the claims of the Amazon patent in question, you discover that Amazon hasn't claimed ownership of the idea of a market in second-hand digital goods at all. Instead, the claims involve merely a very specific and novel method of conducting such a market. Meanwhile, Apple, Rediggy, and other firms have patented their own alternative methods of conducting a secondary digital market. An image of an approved patent letter. The beginning reads, "Your application for improvement in rocket apparatus, dated May 15, 1914, has been examined and allowed." Figure 1. 21. Notice of Examination and Approval of Patent Application. Credit: National Archives and Records Administration via Wikimedia Commons/public domain. Learning objectives. After completing this section, you will be able to describe the steps in the patent application process, discuss the importance of proper claims drafting, applying for a patent. Much is at stake in the process of applying for a patent. Depending upon how you draft the claims and write the specification of your application, you could win or lose patent rights at any point in the examination process. In addition, any patent rights you win can be worth a considerable amount of money and can be enforced by the U.S. federal courts. An applicant must first determine whether to file an application for a utility, design, or plant patent. Then, the applicant must determine their filing status: large entity, small entity, or the new category of micro-entity created by the America Invents Act of 2011, AIA. Small entities, which are universities, nonprofits, and small businesses with fewer than 500 employees who also meet certain other criteria, receive a 50% discount on the application fees paid by large entities. Micro-entities, which are small entities who have a gross income less than 3 times U.S. median household income or meet certain other criteria, receive a 75% discount. These discounts on USPTO fees for small and micro entities do not apply to the attorney's fees often involved in applying for a patent, which can be significant. Provisional versus non-provisional patent application. Finally, the applicant must decide whether to file an abbreviated, provisional patent application or a complete, non-provisional one. A provisional application consists only of the specification describing the invention for which a patent is sought, as well as any drawings that might be necessary to understand the invention. A provisional application is not subject to examination and is viable for 1 year. The chief benefits of a provisional application are twofold. It is much less expensive to file than a regular non-provisional application, only $1,000 in official fees for large entities, $500 for small entities, and $250 for micro entities. It also gives the inventor the benefit of the earlier provisional filing date of the non-provisional application based on the same specification, while measuring the term of the patent from the non-provisional application's filing date. In a sense, the provisional application serves as a placeholder for up to 1 year while the inventor does all the prior art searching, claims drafting, and other work required of a full and complete non-provisional application. This priority date placeholder function can be important given that many companies and inventors are working on new products and services aimed at the same markets. This is especially so under the United States. New first inventor to file, rather than first to invent, priority regime, which some fear may give an edge to large companies with the legal and financial resources to file early and often. To the extent this concern may be valid, provisional applications can serve to mitigate any large company filing advantage. The main disadvantage of a provisional application is that because the written description cannot be changed when filing the follow-on, non-provisional application, all the subsequent claims in that follow-on application must be completely consistent with the earlier description language. As most inventors can attest, the understanding of an invention and its potential market, as well as the claims best suited to protect it, inevitably evolves and matures over time. Here's how an experienced entrepreneur describes the value of a provisional application in the first inventor to file environment. What I recommend to every entrepreneur is that if you write a new, non-obvious, and useful line of code, put it in the specification of a provisional patent application and file it. It only costs $1,000 at most. You then have a year in which to honestly evaluate where the industry is going, where the market is going, and whether your invention is truly valuable enough to pursue a patent for it. A year might not seem very long, but a lot can happen to markets and to technology in that amount of time. Thanks to the rapid rise of smartphones, for example, it took merely a year for netbooks to go from the next big thing to who cares. The first patent drawing for Lizzie Maggie's board game, The Landlord Game, dated January 5, 1904. It depicts a square game board with various rectangles surrounding the border and round areas in the four corners, similar to the well-known board game Monopoly. Figure 1. 22. The first patent drawing for Lizzie Maggie's board game, The Landlord Game. Credit: U.S. National Archives via Wikimedia Commons/public domain. The critical importance of the claims. When it comes to filing a full non-provisional application, the most critical task of the inventor and patent attorney is to draft the claims. This is an art in and of itself, one that will determine the inventor's rights and an infringer's liability. Each claim serves as a standalone definition of the patent coverage, as a sort of mini-patent unto itself. After a patent is granted, a claim is the only thing that someone can be accused of infringing. Accordingly, broad claim language is essential if a commercially meaningful patent is to be obtained. On the other hand, the broader the claim, the more likely it is that prior art may exist somewhere that anticipates the claim or renders it obvious, and therefore invalidates the claim. So the competent draftsperson submits a dozen or more claims, typically moving from broader to narrower scope. In case the broader claims turn out to be disallowed by the USPTO or later invalidated by a court. Some applicants make the opposite mistake and draft claims that are too narrow. A programmable multifunction computer in the shape of a metal clamshell, for example. Such a claim is of little value, because others can easily design around it simply by using plastic or other non-metal materials in the design. Some claims are so narrow they are even referred to as picture claims because they paint a literal and limiting picture of the invention. You may get a patent with such picture claims, but it probably won't be worth the paper it's printed on. The strongest claims usually define powerful functionality. They capture something fundamental or seminal in the functioning of the invention. A good example is the claims in the aforementioned Amazon one-click patent. The algorithms for one-click shopping are not very complicated, yet the claims capture a very profound functionality. The idea that a user should not have to type in credit card and shipping information every time he or she wants to buy something. The consumer-friendly functionality captured in that patent's claims has won Amazon a lot of customers and made it a lot of money. Reviewing the patent application. Once the patent application with all necessary forms is filed and all fees are paid, the patent examiner will review the patent application to determine if the invention meets the statutory requirements for patentability. The examiner will also conduct a search of patent and other databases to determine if the invention appears to be truly novel and non-obvious. Once a determination has been made, the patent examiner will send the applicant a document known as a first office action, in which the patent examiner approves, rejects, or requires additional information about the claims and/or other elements of the application. If all the claims are allowed, which is rare in a first office action, the patent prosecution process is complete. A more common next step requires the applicant to respond to the patent examiner's rejections and requests for more information. In this response, the applicant will address all of the examiner's concerns and either rebut them or amend the application, typically by revising some or all of the claims. But according to the Manual of Patenting Examination Procedure, MPEP, Section 1, 121, no amendment may introduce new matter into the disclosure of an application. Thus, an applicant cannot file an application disclosing a new compound and how to make it, and then later, after discovering that the compound structure and method are incorrect, amend the description. After responding to the office action by perhaps amending the application, the examination process continues until the patent examiner either allows all of the claims or finally rejects them. If all claims are allowed, then the patent prosecution process is complete. If some claims are finally rejected, then the applicant's options at this point are more limited. According to MPEP Section 706(7), in the second or any subsequent examination or consideration by the examiner, the rejection can be made final. At that point, the applicant must usually choose one of three approaches: cancel the rejected claims, leaving only allowed claims to issue as a patent; continue the fight by filing what is called a continuation application and drafting new claims; or appeal to the Patent Trial and Appeals Board, arguing that the patent examiner erred in not allowing the claims. Any appeal to the Patent Trial and Appeals Board, as with any other office action, must occur within 6 months. Finally, if the patent has been vetted through the patent prosecution process and is ready for issuance, the patent holder must pay the applicable fee. If the applicant pays the issue fee, the USPTO will issue the patent in due course. Additionally, utility patents are subject to maintenance fees. These fees are due 3 years and 6 months, 7 years and 6 months, and 11 years and 6 months from the date of the original patent grant. Plant and design patents are also required to pay maintenance fees.